Welcome back everybody to our lessons in land law. This is our final lesson on the subject of easements, focusing in this video on the concept of their termination and the process by which an easement can be terminated. It is the final lesson, as I mentioned. We're going to conclude by briefly running over the process by which easements are terminated. Some of these are very easy to understand. Some of them are a little bit more complicated, but generally speaking, it's a relatively simple and simplistic process. So there are generally three ways in which an easement can be terminated in law. Now, the three ways are as follows. You can see the termination by way of a merger. That is the first way in which a termination of an easement can take place. We can also have termination by way of release. And then finally, we have termination by way of change of character. Let's deal with the easiest one first, the idea of a merger. This is very simple, okay? If there is a merging of a dominant and a servient tenement, then there will be no longer the satisfied and the satisfaction for the requirements of an easement, and so therefore it will terminate. Remember back to previous lessons, in order for you to have an easement, you must have a dominant and servient tenement, and they must be separate. They must be owned separately as well. And so as a result of which, if you do not have this separate ownership, then you cannot obviously have an easement. And so as a result of which, if they merge, if they become one property, then, or they become under the remit and the ownership of one property, of one owner, then this means that they will terminate the easement. The second way in which we can terminate an easement is through the process known as release. Release can be done in one of three ways. You can release expressly, you can release impliedly, and you can release through statute. Okay, an express release will occur where their servient owner acts in a way in which suggests that they have been released from the burden of the easement. So, if you're the servient owner, you have acted in a way which suggests that you have been released from the burden of an easement. Therefore, there will be an express release of that easement, and it will terminate. It can be implied where there is a lack of use of an easement for a long period of time. This is where we get something known as a presumption of abandonment. If the presumption of abandonment is made, it has to be obviously shown, it has to be presumed that an easement has therefore been terminated owing to the fact that there hasn't been any use of or enjoyment of the easement for a long period of time. And then finally, just like with the creation of easements, you can also terminate an easement under statute. This is done, which is on the basis of a number of different things. But one such example is, for example, the compulsory purchase order. A compulsory purchase order will, of course, terminate an easement if that would be a requirement in the purchase of that property. Simple as that. Finally, then, we have change of character. Change of character is a way in which we terminate an easement if there is a change of the use on the dominant tenement, which makes the servient tenement have an increased burden. Remember, the servient tenement is the one that is burdened by the easement. The dominant tenement is the one that is obviously enjoying the right of the easement. If there has been a situation in which the easement's change of character causes an increased burden on the servient tenement, then the easement cannot essentially accommodate that increased burden by reference to the fact that an easement is granted for a specific purpose. If that specific purpose changes, which then gives an increased burden onto the servient tenement, then this will also terminate the easement as well.